We will be dealing with the topic of dying declaration. Section 32 Clause 1 Indian Evidence Act. Section 32 says statements, verbal or written, which are related to relevant facts made by a person who is dead, cannot be found, incapable of giving evidence, whose attendance in court cannot be procured without unnecessary or unreasonable delay and expenses. In such cases, their statements are accepted as evidence under section 32 because they are not available. Either they are dead, they cannot be found, or whatever the reason is, they cannot come to the court. And hence section 32 is known as hearsay evidence, or exception to general rule that hearsay evidence will not be accepted. Section 32 clause 1 talks about dying declaration, and since witnesses are not available, the person who has made the statement is died, so he is not available, so cross examination cannot be done, and court cannot observe the demeanor, the behavior of the person who will be, if he is in witness box, then during cross examination court observes the confidence level and other things, the body language of the witness, and then court goes on up to what extent he should be trusted or not. So because witnesses are not available, such things are not happening, so court is not bound to rely without corroboration. But if dying declaration is recorded properly by magistrate or even by doctor and appears truthful, conviction can solely be based on dying declaration. Section 32 clause 1 says, if cause of death in whatever proceeding is in question, then any statement by the person as to cause of his death or as to any circumstances of transaction which resulted in his death, such statement is relevant. So here, in case of death in whatever proceeding, illustration A to section 31 talks that both civil and criminal proceedings are covered here. And then any statement means verbal, written, and conduct. If we go by the reasoning of Queen versus Abdullah, then the conduct of Dulari was in question and it was considered to be as statement. Then expectation of death at the time of making the statement is irrelevant. Expectation of death at the time of making the statement is irrelevant, meaning thereby the person is not required to be under the expectation that he or she is going to die while making the statement. So basically dying declaration means a statement made by a person as to cause of his death or any circumstances of transaction which resulted in death, and after making the statement the person is no more, he has died. So hence someone else, for example magistrate who has recorded or doctor who has recorded, they will be putting this dying declaration into evidence. So that is how it is also called as hearsay. And what is the rationale behind? The underlying rationale is that person on deathbed will not lie and he will speak truth. This is the rationale. However, it is not just because of this rationale it will be accepted, but there are sound judicial decisions and rulings based on which it is being accepted. Now in Pakala Narayan Swami versus Emperor, Narayan Swami, he gave loan to the accused person, and accused person wrote him a letter to come and take the money back. So Narayan Swami told his wife that he is going to get the money back, and he left his house, and thereafter he was murdered by the accused person. So his statement to his wife and the letters which he shown to his wife that he is going to get the money back were considered as dying declaration. Now here he was not under expectation of any death, but this statement which was verbally made to his wife and letters were shown, this statement shows the cause of his death or the circumstances, as the case you would like to interpret and find it more convenient. However, it is much akin to the circumstances, because he went there to get the money back, and he, instead of giving money back, the accused person killed him. In Queen versus Abdullah, Abdullah killed one Dulari by slitting her throat, and while she was being asked questions in sign language, she was asked question, but because her throat was slitted, so she could not speak. But by virtue of sign and signature, she made it ascertain that Abdullah did this. So in this case, it was in question whether such statement can be considered as dying declaration or not. So court came to the conclusion that yes, it can be. However, Justice Mahmood also asserted that it is relevant under section 8 conduct, under the part of conduct, Indian Evidence Act section 8. However, it was also considered relevant, and it was said that statement under section 32 clause 1 means verbal, written, and it includes conduct also, sign also. So through sign language, Dulati told that Abdullah killed her, means slitted her throat. As to proof, section 104 Evidence Act talks about any person wishes to give evidence of something must prove it. Hence, if prosecution wishes to give evidence of dying declaration, prosecution must prove it. Furthermore, section 136, it says, if fact proposed to be proved as one, of which evidence is admissible only upon proof of other fact, that fact shall be proved. So, if fact proposed to be proved is dying declaration, of which evidence is admissible upon proof of other fact. So you can give dying declaration. For that you need to prove that maker of the statement is dead, he or she is no more. That fact shall be proved first. So first you need to prove death of the victim, and then you can put dying declaration in evidence. Now, statement having causal connection with death or with circumstances of death, which do not bear any proximity with death, or which are connected very remotely with the death, are not admissible. So which are having so causal connection that they do not bear any proximity with death, or connectivity is very remote, then they will not be accepted as dying declaration. Sarad Bridhchandra Sharda versus State of Maharashtra, in this case, statement by the deceased in writing and in verbal mode. He made statements which were kind of putting a notion towards the reason of her death. And indeed, court bring it out that what was the cause of the death as per the available evidences. So this statement stated that yes, what was the result of what the probable result of the death, but it did not work typically as dying declaration, because dying declaration means it is showing reason of his death and the accused person is being implicated. However, something else happened in this case. What happened? She made the written statement through letters to her sister and friend, and then verbally also to her father, mother, sister and friend. So now there were multiple dying declarations, obviously. So in one letter, what she asserted, now before going with the content of the letter, we'll see what actually court found that she said in this dying declarations, both written and verbal. She showed her state of mind shortly before death and made complaint as to ill treatment by husband and also by in-laws, which will be there. So in first letter which he wrote to her sister, she said, I am going through difficult time trying to hold myself, but if it becomes impossible to hold, some other way has to be devised. And as she is in her husband's house, so place of daughter in her husband's house is not more than a laborer, and she had only wished that his husband would take care of her, but that is also not happening. That dream is also shattered, and it's destiny and luck only. So she want to means it's in her letter, I want to tell you everything but I cannot tell you. So she is writing that it's destiny and luck only. I want to tell you everything but I cannot tell you. So based upon this statement by the deceased, court was of conclusion that deceased was highly emotional and sensitive person and got shock of her life due to ill treatment by husband and in-laws. She wanted to keep all her worries and trouble to herself, but no serious allegation of cruelty were made against husband or in-laws. And in fact, by going through the case law, when you will go through this case law, you will find that no serious allegations have been made. But yes, she had stated that ill treatment is there, but her letters and her statements are not kind of implicating husband or in-laws, because in criminal law we need to go beyond reasonable doubt, and if there is doubt, then benefit of doubt will go to accused person only. In another letter to her sister, she mentioned that I am happy here, and other events are also fine, but means she did not say anything against her husband or in-laws. She said I am happy here and talked about other event, but she did not say anything about her husband and in-laws treatment. But she also mentioned that due to some apprehension, she was not hopeful to go to his father's place. Now in her letter, some kind of apprehension, some kind of fear is there in his mind, but it is not exactly clear that fear or apprehension is because of ill treatment, that they will kill her, because she has never stated that. But her letter and this further letter to friend, it will reveal that she was kind of some emotional stress and she was not able to pick it up. Obviously there are circumstances that yes, she was being ill treated, but that does not mean that husband and in-laws killed her. So letter to friend says, people here are good but all are elder. I cannot act independently. My husband does not take care of me. The day self-pride is lessened, no other person would be more fortunate than me. But that day it will not be certain that I'll be alive. Her condition is no more than maid servant, that's so without pay. So these are the relevant extract which I have taken from the judgment and placed here for in simple language for the purpose of understanding. So based on these statements, court found that she was under emotional stress, she was sensitive, and it, as stated by the counsel also, it may be possible that she has committed suicide. Instead, husband and in-laws killed her. So these statements are very vague. They have no proximity with that. They are not connected with the death, as per the technicality of section 32 clause 1 dying declaration, because dying declaration shall incriminate the accused person, but here it is not so happening. What is coming out of that? She might have committed suicide. She was under emotional stress. She was kind of a different person who wanted to keep things with her, and there was some fear and apprehension, but what was that exactly is not being portrayed. Just mentioning that ill treatment does not mean they have killed. So beyond reasonable doubt is also seems not to be covered in the sense not to be established by the prosecution, and from the extract also court has found, and hence they were not convicted. Now some of the conditions which are relevant as to dying declaration: it should be made in form of question and answer. Words to be recorded verbatim, means as it is, there shall be no variation, and no opinion or one's judgment should be written over there. What is being told by the victim and now the deceased person should be written as it is, should be recorded as it is. Now statement should be complete. For example, if A says, now deceased A said that B pushed, attacked him, and so this is incomplete statement, not giving any any notion or any conclusion. So statement should be complete. Now maker of statement shall be in fit condition mentally and physically. So these relevant doctors, medical officers are to be consulted before recording that whether the person is in fit state of mind or not, fit state of health or not, because these things affect their judgment and obviously their narration also. Now dying declaration may be recorded by any person, by doctor, by executive magistrate, by police officer by virtue of 162 CRPC, by magistrate by virtue of 164, and doctor, medical officer's opinion as to fit state of health is also required before, because these things make dying declaration much reliable and substantive piece of evidence, which will be covering further also. Now in case of multiple dying declaration, what should be done? So now the question is of reliability. Okay, reliability is the main essence, is the core, and not the number of dying declaration. So this case in Sharda versus State of Rajasthan, what happened? There were 3 dying declarations. 2 were made before, one was made before doctor, another was before police, and another was before executive magistrate. So doctor and police, before doctor and police, statement was made that injury occurred due to stove burn. She was working on the stove, and because of that she sustained the injury. Now before executive magistrate, the victim said mother-in-law poured kerosene on her and burned her. So in first statement there is no mention of mother-in-law or any other person, but in second dying declaration it is relevant. So court overturned the conviction and said that 2 statements are there. In such time corroboration is required because 2 are different, they are not same. So corroboration is required, and based upon the facts of the cases, the prosecution failed to establish the guilt of the accused person. If all dying declarations are consistent, then they can be relied upon. But if not, then corroboration is required. And same was said in Sudhakar versus MP AI 2012. Another case of dying declaration in Makhan Singh versus State of Haryana. What happened? There were 2 dying declarations before 2 different magistrates. First dying declaration stated that she was ill, mistakenly took wrong tablet. She died because consuming a poisonous tablet. So she before dying made the statement that she mistakenly took the wrong tablet. She was ill and she mistakenly took the wrong tablet. But the second dying declaration, she stated that her husband and his parents, means her in-laws, they administered the tablet forcefully due to the demand of dowry. They were demanding dowry, she could not fulfill, so they administered her the poisonous tablet. Now in this case, DSP, Deputy Superintendent of Police, he said that no witness is supporting second dying declaration. None is on the record with the investigation which is supporting second dying declaration, and it is possible that it is made due to deceased being tutored by the relatives. It was recorded after 3 days. And opinion of medical officer was also not taken. So in this case, court found that prosecution did not cross-examine the magistrate who recorded the first dying declaration. This magistrate was not cross-examined, neither the DSP. Both of them were produced as witness by the defense counsel, but prosecution did not cross-examine. So court said that this create a doubt on the impartiality of the IO, investigating officer. Look, prosecution needs to establish the guilt, but that does not mean they will implicate a person unnecessary. They have to look out the truth, that's all. It does not mean that they have to sustain the conviction at all cost. But this is not the topic of this current subject matter, so we'll discuss sometime later on. And court said that no opinion as to medical fitness of the deceased was taken at the time of recording of second declaration. So court said that dying declaration, if reliable, trustworthy, formally recorded and deceased was medically fit and there is no sign of stress or no tutoring was done, then it can be sole basis of conviction. But it does not seem in the current case. So court did not accept the dying declaration. Now evidentiary value of dying declaration in Kushal Rao versus Bombay, year 1958, and from these cases also it comes to be out that it is a substantive piece of evidence and requires no corroboration. Its reliability depends upon case to case. So if it is formally recorded, reliable, and witness was this deceased person was medically fit at that time, then it is a substantial piece of evidence and requires no corroboration. Obviously, no corroboration does not mean that court is believing it just like that. Obviously, it is formal and based upon the fact before the court. Court is convinced that prima facie, yes, it is reliable and can be accepted. So corroboration does not mean that court is accepting is arbitrary. No, these are the judicially determined precedent and practices following which court accept the dying declaration. So this is all about dying declaration. Hope this will be of help.